admit everybody. Here we go. And it's going to take a little bit for everybody to get in, of course. And we just want to ask everybody to mute yourself upon entry, and please stay muted until question period starts later in the meeting. Just we ask everybody to stay muted, and also keep your video off if you can. And yeah, I think that's all of the preamble. And we're just waiting for more people to come in before we start everything. We're expecting maybe 100. What do you think? 100, Rose?
Oh yeah, there even more registrations came in. I sent Matt a note saying that we were at 123, including his team, and then more registrations came in after that. So maybe the timing is just a titch too early for some people. Here's another registration. Here's another one coming in.
Yeah, we've already got like 66 so far
I think
joined.
that's more than enough.
66
So,
are here?
68 participants right now.
Okay, does the Marshall team mind if we wait a couple minutes?
No, you go ahead and let us know when we've got a few minutes. So.
Just want to continue to remind everybody, especially the new entrants, if you could stay muted until it's time to ask questions. When you have a question later in the meeting, we'll have an arrangement where you might put your hand up. Just please stay muted for now at the beginning. And we're just waiting a few minutes until everybody joins. We have perhaps 100 people joining, and there are 72 joined. So yeah,
They're rolling
And,
it now.
they're rolling in. So just a few minutes and we'll start the meeting. Today we have David Marshall, who will
Good.
thank you for being here, and
Not at all.
he'll do a presentation. And I guess we could start any time now.
Yeah, we can start, I think.
I will continue to let people in to the meeting as we go.
Sure. Okay, well, thank you for that. And just so you know, so everybody watching knows, we've also got Matt Marshall here, a lawyer at our office. We've got Matt Jarrett joining us as well from our office, and Jason Martin, all lawyers in our office. So I've got about probably, I think, about 10 minutes of a bit of an intro that I want to give to you folks. I was thinking of starting off with a little bit about our firm, a little review of the problems at issue in respect to the LTB, an overview of the impact that these problems are having on small landlords in the province, some of the things that we're seeing, and then we'll go into discussing what our firm is suggesting at this juncture to bring the matter before the judicial branch of government, and of course the grounds for the proposed court challenge, and an overview of the steps for suing the government. And then finally, I guess we'll open the floor to some questions about our presentation and the path forward. One thing we're probably going to avoid, I think, is if we can avoid specific questions about specific issues that individuals may be having, matters before the LTB. Those should all be discussed candidly and in the under the guise of solicitor-client privilege. So we'll try to avoid that. But I'll start in with a little bit about our firm and what we do. So the Marshall Law Group, it's a litigation-focused firm. We take cases that range from contractual disputes to acting for municipalities and companies, families, and things of that sort. Our focus is, of course, on going to court. We know how to go to court. We like going there. We're comfortable there. Our firm has got a lot of experience in respect to administrative law issues, which is critical here, and some of the issues that are deeply in play in what we're proposing, issues like fundamental justice, principles of natural justice, and the role of the judiciary in policing the government. I can tell you a little bit about myself. I've acted for municipal governments in respect of disciplinary and administrative law issues. I co-authored the rules of practice and procedure for the Toronto Local Appeal Body and acted as its counsel for some years. We're keenly aware of how boards and tribunals work and their functions and roles in the administration of justice in the province. I want to turn a little bit just to chat about some of the problems that we're seeing. I think if I can provide sort of an overview and then we'll go into some specifics. The problem at hand is that we have an unbalanced system when it comes to landlord and tenant board issues. It's a system that disregards the needs of small landlords and takes them for granted. And in doing so, it imperils their financial security and in some cases, their physical security. And of course, their family's future when their finances are at stake. We have in this province a system that is consequenceless, lacking in consequences when it comes to tenants who behave badly, who don't pay their rent, who damage private property, and in many instances engage in dangerous and violent activities, and who ultimately ignore orders of the landlord-tenant board, really with impunity, with no consequence. And the situation is notorious. This is the part of the problem here, is that it's well known. Tenants know, as a matter of fact, somewhat like knowing that gravity will keep you on the ground, that they can avoid paying rent, oftentimes well in excess of a year, all the while using utilities, water, hydro, heat. And of course, they're safe in the knowledge that the landlord-tenant board is slow to hear matters. I think that's a nice way to put it. Quick to delay and adjourn matters. And of course, finally, and perhaps worst of all, toothless when it comes to forcing tenants to leave, to pay, and to make good on damages and losses suffered by landlords. I can tell you that we've got clients that have these types of situations. We've got a lot of people who are first generation immigrants to Canada. And I can tell you it's a depressing thing to have that conversation, to say that there are significant problems with our system, because you can see in their eyes, and sometimes in their words, their realization that there's this vast chasm between their expectations of Canadian justice and its and the reality of justice. And to give you some practical examples of the types of things that we're seeing, we have clients facing tenants convicted of violent crime, drug trafficking charges where guns are present in the units, and where appeals to the landlord-tenant board for a speedy process don't even get an email response. So that should shock the conscience. It certainly shocks us and continues to do so. We spent the better part of February, in respect to one client, we spent the better part of February, March, April, June, July, and August calling the landlord-tenant board daily, in some cases twice a day. And during those several months of calling every single day but Saturday and Sunday, we got through twice. And in the second call, for technological reasons, the phone disconnected. So you can imagine the frustration. And that was merely to check up, to find out where in the process our client's matter was. In other cases, we've advised tenants who are losing their homes, can't make the rent, the mortgage payments. I saw in the news yesterday or the day before, a CBC report, a fellow sleeping in his car. That is not news to us. We're seeing this on the ground in our practice on a regular, too frequent basis. And I think, frankly, it's hard to overstate the problem that's facing small landlords who perhaps own a duplex or something like that. They've got a mortgage and mortgage payments to make on a monthly basis. And they've invested in the unit, and the unit being rented out, of course, would ideally go to somebody who's going to be a partner in that rental situation. These are small individual, they're not, these are not big corporations we're talking about. These are not landlords off in some far-flung country or sitting high on the hog in their penthouse. These are mom and pop type operations, and they're at risk of losing their homes and being able to support their families. And to be frank, what we're seeing are delays that are sometimes well in excess of 10 months. And when we get to hearings, they're chaotic, where dozens upon dozens of tenants and landlords are waiting hours upon hours to be heard. And then if by some miracle the hearing takes place and you've had your say, you're then waiting some 60, 70, even 80 days to get a decision. And at the end of that, of course, you're facing the debts and losses of those several months of not receiving any pay. You've still got the difficulty of removing the tenants. That's another process in itself. And then, of course, for many people, and far too frequently, cleanup and repair of the damage done. And the first question is, where's that money coming from when you've had nothing coming in for months? Now, the result of all this is that landlords are losing their properties and they're choosing to sell. And in some instances, we've had people say we're selling, and they do. And in others, we've had them simply say we're not renting again. And they've closed up their operations entirely. And so that's not helping what we hear is a significant housing crisis in the province. And it must be remembered that, in this situation, the Landlord-Tenant Board has a monopoly when it comes to Landlord-Tenant Board issues. And the whole point of a legal or administrative judicial process is to stop people from settling disputes in the streets. So to be effective in achieving this goal, courts and administrative bodies have to deliver on the promise that they make to Canadians to be an effective and just place for the settling of disputes important to the people in this province. And the effect of the LTB's failure, and I don't think it's hyperbole, is to say that it's a failure of civilization. It's a failure by those with a monopoly on the use of force to provide an accessible and just mechanism for the dispute resolution process. And it's a breach of what one of my favorite philosophers, John Locke, said. We engage in a social contract between the governed and the governed and those in power. And when they breach that, they're in breach of a fiduciary duty, or of a duty to do what they say they're going to do for us. So that's, in a nutshell, what we're seeing on the ground when it comes to landlord and tenant board issues. And it's not something that I think you can overstate. Specifically this week, we've been in touch with fire departments, with chiefs of fire departments, the police. We have tried virtually every lever there is available, short of what we're proposing, to try and help our clients. And the reason that we're here is because we've come to the end of that road, I think, and something needs to be done. So with that said, I think now we probably should give you a sense of what it is that we're thinking of doing. And for that, I'm going to let Matt take over there and give you a sense of what that looks like.
Hi, folks. Are you able to hear me all right?
Yes.
Okay. So the question really is, what are we going to do? What are we proposing? What we're really proposing is that, one landlord or several landlords with similar circumstances would bring a claim against the government on the basis that these extreme delays and the harm that is arising from those delays reach the level of an abusive process. As David has discussed, the government has a legal and a moral obligation to keep their processes running smoothly. And they have shirked that responsibility completely. So what that legal action would be asking for, in a perfect world, that would result in three things mainly. The first would be an order of mandamus. So mandamus is essentially a sort of command that the court can issue to government officers to do their duty. And this can take many forms, but the goal would be to force the government to maintain and run their systems in a way that doesn't injure those that are forced to participate in them. Beyond that, the claim would also be for damages and costs, partly to compensate the injured parties, but also to attempt to inflict a penalty on the government for their improper conduct. So obviously a big part of any legal proceeding is assessing risk. This is not really a field or a job where you get to give many guarantees. It's possible that a court wouldn't grant any of these things, and even that costs would be awarded against any plaintiffs. While we are proposing to work on this application and not charge for our time, there's still a financial risk attached to any court proceeding. I know Bob has provided you with some materials regarding ideal plaintiffs or who we're looking to speak with, in particular regarding this sort of thing. But essentially that person, I know many of you here are probably that person or people, someone who's experiencing these delays, as many of you are, someone who's actively suffering as a result of those delays, and someone who's done what little they are able to do in order to try and expedite the deeply flawed process. So my colleague David is going to speak a little bit about what next steps would be, and then I think we're going to open the floor up to a few questions about this. Thanks.
Thanks, Matt. Matt, do you want to talk briefly about what this ideal person or plaintiff looks like, or do you want me to kind of? Matthew?
Yeah, so essentially we're talking about someone who is, like I said, experiencing undue delays, someone who's not been waiting 1 month or 2 months, but someone who's been waiting upwards of the higher end of the delays that we've seen, someone who's experiencing significant prejudice due to this, be that financial, emotional, or sometimes even physical issues that are arising from these things. And then when I speak about what little can be done in terms of expediting things, that would take the form really of a request for an expedited hearing.
Yeah. Okay. And I think we're looking for, one or more. And we're considering something that I'm sure is on the tip of all of your tongues, which is a class action lawsuit, which is another avenue that we're considering. But the type of action that we're considering is really a private action against the government, where individuals are saying we've got problems, and here court is what's happened to us, and we think that the bad party is the government, or the LTB and government, because of what they're failing to do. So in that regard, as Matt said, it opens up the private litigant to the potential of a cost award at the end that may be adverse if they're not successful. But we're not proposing to charge anything for our time to the individual. So it would be in that regard risk-free, but it doesn't mean that there wouldn't be a potential if there was a loss. To give you some comfort, most of these matters are either resolved by agreement with the defendant, or some other resolution is made. Part of what this process is about getting results. And if we can get those results by getting the government to act properly and to do what's required by the law, then there won't be a need to go the full distance, and that will reduce that risk to zero, for example. A lot of you have suffered significant financial harm and may not be in a position to fund this type of thing, and that's why we're suggesting essentially that we do it to gratis, without cost. In terms of next steps, we've got to do a few things. We've got to find those ideal plaintiffs, meet with them. I'd like to meet with them physically, so if they're in Southern Ontario, that's certainly easier. There are now in the post-COVID world all these wonderful technologies like the one we're using that make it possible for us to meet people elsewhere, and that's fine too. We want to get their stories and understand the facts, and then we start to put together what's called an application containing affidavit evidence with physical documents appended to it that show what you're going through, what's happening, how the delays, for example, are causing injury and losses to you. And then we want to put that before the court. And that's a process of issuing the application and then serving it upon the government. Now, there's a bit of, there's a few steps that you have to take when you sue the government that you don't have to take when you sue an individual. One is giving the government notice that you intend to bring an action against it, and to give them a sense of the nature of that claim. And if you're going to raise things like constitutional issues, that sort of thing. So that will probably bring us into the new year before we're in a position to launch. But we'd like to get going on that sooner than later. So to the extent that any of you think you fit the bill, so to speak, of our quote unquote ideal plaintiff or plaintiffs, we'd like to hear from you. So I think Solo has perhaps already provided our contact details to you. The main line is my cell phone, and I take phone calls till about 11:30 at night, and so I'm available. And you know, we already understand a lot of what you're going through, so what you tell us probably won't be news to us, but we're here to listen. So, Matt, is there anything else from your perspective that we need to discuss?
Yeah, I'm seeing a couple of questions here in the chat regarding potential risks if the lawsuit were to be unsuccessful, if any potential application were to be unsuccessful. So I think it was Tariq who said that. One of the main things when you are dealing with any legal action is that if it's unsuccessful, generally the party that is successful has a portion of their costs paid by the losing party. So that it's difficult to estimate what that number would be, but that is always an inherent risk when you're dealing with court actions.
So Matt, I think we need to get some specific, sorry, I know we can't be specific, but if I was listening as this group, the strategy, the amount of money that you think it might add up to, and how is that money to be raised? So if there was one plaintiff, then everything could be funneled into that direction. But if you're suggesting that it be one or several plaintiffs, does that mean that there has to be losses? Like, say, for example, the loss, you had to pay the winning party. Say we lost $40,000, but there's 5 plaintiffs. Is that 5 times 40?
Okay, good question. I think I understand, Rose. So cost of litigation is high. And when you lose, you typically pay somewhere between 60 and 90% of the other party's cost. Now that cuts both ways. So in the event that you're successful, of course, your costs would be paid. Your costs to you are nothing, but we will be banking our time so that in the event that the matter is successful and you are the victor, that the costs that we've incurred get paid. So we're taking a risk that it doesn't go your way and we get paid nothing for our work. But in the event that it goes your way and you're successful, the government will be paying between 60 and 90% of our bill. Now you'll ask, well, what's that bill? And that entirely depends upon how aggressive the government is in pushing back and how many lawyers they throw at it. But you can expect somewhere between $20,000 and $150,000 in costs awarded against an unsuccessful party. The courts will be cognizant of the situation and the reasons for the bringing of this application, and that may impact any cost award that would be awarded against you, but the numbers are big.
Okay, so if one plaintiff comes, that's what the range would be. What if there's 2, 3, 4, 5 plaintiffs?
Yeah, good question. So if there's 2, 3, 4, or 5 plaintiffs, that cost, if it were to be awarded against, if you were unsuccessful and it was awarded against the plaintiffs, it would be borne ostensibly equally between the 5. The court doesn't care how it gets paid, and the victor doesn't care how it gets paid. So it could conceivably seek it all from one or all together. And as long as it gets paid, that's not an issue. So that would have to be worked out between the plaintiffs. And we would have a very careful discussion with the plaintiffs about coming to an agreement beforehand about how to deal with costs in the event of a loss and how that burden would be shared between them.
Okay, so just to clarify, let's just say that the payout, the loss payout was $20,000. If there are 5 plaintiffs, is it 20 times 5 or is it just 20?
20.
Okay, that's actually good news.
Yeah, it's not as bad as it sounds. The bigger the boat, perhaps the lighter the rowing, so to
Okay,
speak.
good question. Once you have these, this is Buba, the chair. Once you have the ideal plaintiff, and let's be optimistic and say successful, how the people who are not on that list, how will they benefit?
It's a good question. And so, and we talked about this because I in fact I see one of the questions in the chat here saying, why is it not a class action lawsuit? We're contemplating a class action lawsuit. That is in our matrix of potential avenues forward. But how it benefits others is an interesting one, because it's a bit like blazing a trail. If we are successful, it charts a course forward. Our judicial system is built on precedent. That is, former decisions weigh upon present decision making. And so if we can chart a course forward by establishing a route for small landlords to seek redress when the landlord-tenant board won't or can't, that provides them with an avenue. And it's a bit like each time somebody goes over that ground, it gets a bit smoother. So we're trying to chart a way forward for landlords.
Okay.
There's a lot of questions in the chat. I don't know whether you want us to turn to that briefly, or there's so many.
Yes, there's one question from Karen. How many applicants are you looking for?
I don't know the answer to that. I think if we had 5 or maybe 10, the difficulty with multiple parties is always it's a bit like herding cats. Some people want to jump off early and don't want to partake. They may have their matter resolved at the LTB and no longer have an issue or an axe to grind or a burden to bear. It also becomes difficult when you have multiple parties coming to a resolution. The government may propose certain, certain settlement positions agreeable to 2 people, not agreeable to 3. And in those circumstances, that puts the lawyer in an impossible conflict of interest. So the more people we get on this, the harder it does get to go in the route that we're presently contemplating as a primary strategy. In a class action lawsuit, that doesn't obtain, that same pressure isn't there. And we can proceed with a representative plaintiff and bring the matter to the government in that way. And in that case, we would be discussing settlement issues and dealing with those things from the lawyer's perspective, not necessarily with each individual potential beneficiary of a class action lawsuit.
There's a question from Tanya. Is it all right that you have people that are actively waiting for hearings, or in any particular state, whether they have an order or not have an order? Does it matter how far along the process they are, or even that they're in the process?
Yeah, not exactly, but I mean, what we're looking for is somebody who is, not been paid rent or has some other analogous issues. Some of the things I talked about in outlining the problems, has gone to the LTB to seek redress because that's where you have to go. Hasn't gotten redress, has applied for an expedited hearing and is still waiting. That really kind of sharpens the wedge here. Those are the types of situations where it's difficult for us to conceive what the government's answer could be for inordinate delay causing damages and losses to individuals. In any other place, I don't think that would obtain. So the ideal person is somebody who's really got a critical situation and isn't getting relief.
Great. Marissa has a question. Will the LTB know who's involved, or like, are all the landlords' names going to be exposed to the LTB when an action occurs?
Yeah, great question. It's a public process. The courtroom is open. If you make a complaint about somebody or something, you have to answer for your complaint. You have to be accountable. So it's a public and open process. When you make a claim, your name will be on it. It will say, whoever, Ann Crow versus the province of Ontario. So it's gonna be there. It's gonna be open.
Okay, Michael, you have your hand up there. Maybe
Oh, thank you.
unmute. You have a question?
I do, yes. David, I like your vocabulary. I'm not, I can't speak the way you do, but it gives me a little bit of comfort. I think you speak realistically when you describe this as a failure of civilization. I was wondering if you could talk a little bit more about what is really going on. I read the stories like online, and it's always presented as there's a backlog and they're trying to hurry up. And then I read the tragedies about homelessness, bankruptcy, families falling apart, suicides. And you use the phrase, people who, the LTB is intended to prevent people from resolving disputes in the streets. And I'm just wondering, like, what is really going on in Ontario? Like, powerful people are obviously watching this, federal and provincial. They're smart, they've got law degrees, they've got tons of experience. If people can see a failure of civilization, and like, other than you and others, few others, there's really nothing happening. And what does that mean? Like, what world am I in?
Yeah, good question, Michael. So I think there's a political element. I always talk about law as politics in action. And these are not sexy issues. And justice is not in the forefront, or issues of access to justice are not always in the forefront of our political leaders' minds. And we have a political climate in Canada that villainizes landlords and caricatures them as big fat cats. But I think if you look at the screen, I'm seeing a lot of people who I think are average mom and pop folks who perhaps came from another country and are looking to set up a future for their children. And none of that is taken into account, and none of that appears in the caricature of the nasty landlord. Now, to be sure, there are landlords out there who do bad things. That happens, but it doesn't happen that frequently in my experience. And in my experience, the caricature is not representative of the vast majority of landlords in Ontario who are trying to make ends meet, provide some additional housing for their neighbors, maybe a friend of a friend. And when things don't go right, they're looking to the government for help, and it isn't there. The whole purpose of government, of organized civilization, is to do things that we can't do as individuals. I can't build a bridge, don't know how, but I know that we can together build a bridge. When the government fails in organizing our system, in having a system that's organized to help people, that is the sine qua non of the civilizational failure. And this is what is happening to people in Ontario. And there's a couple of options. You know, the courts are good places for justice to be achieved. Those people that are peopling the judicial system proper, the Superior Court of Ontario, they're smart people. They understand the technicalities don't mean you lose your spot in the queue and have to go back to the back of the line. They have discretion to ensure that the equities of the situation are paramount in determining the rights and wrongs before them. We don't see that at the Landlord Tenant Board very often. I was witness about a week ago to a poor lady who hasn't been paid rent for several months, but she got the date wrong on the document. Now, the document was never successfully served because the tenant won't accept any documents. So the fact that there is a mistake on the document is inconsequential. But she suffered the same fate that I'm sure some of you have either heard of or seen or experienced yourselves. Back to the back of the line she goes, and she will be, unfortunately, another year, perhaps, waiting for a hearing, all the while paying for the electricity, for the utilities, for the water, the hydro, and not receiving any rent. And probably, I don't know this in this particular situation, but paying the darned mortgage all the while and providing free housing for somebody. It's quite shocking.
Okay, so we have a question from Siddharth. Now, if you managed to get the action started in January, what do you estimate the time frame for the whole legal action from start to finish? What do you think how long do you think it might take?
Applications are meant to be short. My experience is that they're sometimes a little longer than you hope for. It's meant to be a vehicle for getting things in front of the court quickly through truncated presentation of evidence. There sometimes is an cross-examination process on the affidavits. It could be in the range of anywhere between 2 and 6 months to get it in front of the court. And remember, I think part of me wants to say, I just want a result. I'm not particularly interested in getting a judgment if I can get the bloody result either way. And I think that should be the focus of everybody who contacts us, is at the end of the day, you just want this fixed.
And do you have a deadline for the people that will come to you?
No,
you're just ongoing, you're going to keep asking for
If I can interject here, we're going to start reaching out to people next week, but we don't have a specific end date. If people want to contact us next week or the week after, that's perfectly fine.
Okay, great. Hazanan, hopefully I'm saying your name right. You have your hand up. Can you unmute and ask your question?
Yep. Hasnain here. My question is, I have a couple of small questions. Firstly, considering that there was an emergency and the government used the emergency under the guise, does that give them a free pass? In this case, does that cause a less likelihood for success for the plaintiffs? That's just one thing that I had in mind. But another thing is, I hear you mention, people might be in their different stages with the LTB, who may be a plaintiff. But what about people that have already gotten their judgment? The tenant has been evicted. There's no way to get the money, and you're at a loss because of the delay. So that's the other question. Would those be also be considered as part of the plaintiffs or not?
Good question, Hassan. So let me start with the pandemic one, and then we'll go to the next one about what happens to people who maybe have damages or losses but have finished the process. So in respect to the pandemic, yeah, that's an issue. That's the excuse. That's, as I think you said, the card that they will play or the free pass that they will seek. But whether at this juncture the court will buy that argument, a year and a half, 2 years, 3 years into the process, I think that the question will be, what is the tolerance of the court for delay that exceeds, what is really permissible. So given the extraordinary circumstances that they will no doubt point to as the excuse. The second question is people who have finished the process and maybe have damages. Well, part of that comes back to my idea that it becomes well-trodden ground. I think if we can show that those types of delays that people are suffering or have suffered, and they're within the 2-year limitation period for bringing a claim, they may well be able to bring a claim either through our office or a lawyer of their choosing, or even individually against the government for recompense. And they will be able to point, if we get a judgment, to that judgment to say, there is delay and the court found that that led to damages and I've got the same damages. That will expire 2 years after the damages have at least crystallized, I think, but I don't want to pronounce on what the limitation period will be, but the general limitation period on Ontario is 2 years. So.
Sorry,
Okay.
just one more point. I heard you mention that the LTP is toothless, like they can't really make the people pay. So would that also be something that would be part of a lawsuit saying that, why should a tenant who gets a judgment now has to go to another court to actually get the tenant to pay? Like, I mean, something to make changes, like something that would bring changes in the way the system works as well.
Yeah, my hope is that this leads to some introspection on the part of our government about what needs to be changed to fix the system. Part of the toothlessness of the LTB is not simply that it's toothless, though I think that's the case, but that often tenants are judgment proof. Our system is built on the premise in the civil system, is built on the premise that you have something to lose. And so an award against you has a consequence because we can seize your truck or we can seize your home. And sometimes tenants are effectively what we call judgment proof, or what we might say is trying to get blood from a stone. And so you can get an order and it's worth simply the paper it's written on and nothing more. That's part of the toothlessness of the situation. One of the thoughts that I've had for some years is if a tenant comes and they haven't paid the rent, it should be a hard day to get before the landlord tenant board. Pay up and then you can have your say. There's a few thoughts like that that really the government should consider. The other is that when it comes to cost consequences and a loss at the LTB, if you bring a frivolous claim against the landlord, for example, or vice versa, that you pay the consequences of your bad behavior. Frivolous claims should be punished. And there should be a way of holding people to account for that.
Thank you.
Yes, thank you. Now we have Subra with a question.
And I just
Please,
want to interject here, folks.
yeah.
I think this is going to be our last question because we unfortunately have another meeting after this one.
Okay.
Busy place.
Yep, no doubt. Go ahead, Subra.
Hi, David. Thank you very much for raising that issue of civility. In that context, I have two questions. One question is that whenever we have contacted Ombudsman or Attorney General's office for raising our complaints, we have always been told that they don't want to interfere in the independence of landlord and tenant board. And second thing, I have been contacting many lawyers, including constitutional lawyers, with a long-term view of changing this RTA 2006. But I was surprised to see that there was hardly any response from them. That's why my special thanks to you that you addressed few things which I wanted to hear. And second thing is that one lawyer I was successful to communicate with, they mentioned that they have to look into the conflict of interest. That means probably the Crown Prosecution Act, which probably bar anybody to raise any legal issue against the landlord-tenant board and the government. Okay, but we could not go ahead with him, and because considering the cost, some vague idea, there was no idea about the cost. And my third question, if you can remember, sorry. When you say cost, What do you mean by that? What does it constitute of?
Okay, so the last part, Subra, so just so I understand, you mean the cost consequence in the event of a loss, or what are you?
Yeah, what are the costs comprised of? What are the
Okay.
costs?
Yeah, so I'll answer that one right off the bat. Cost consequences are principally lawyer fees. Lawyers are expensive. And going to court is expensive, and documents. You get a lot of people in a room arguing, very complex legal issues. It results in costs. So those costs that if you were unsuccessful, you were the plaintiff and you were unsuccessful, you can expect to receive a cost award against you. It cuts both ways, as I say. If you're successful, you're entitled to have your costs due. There's somebody there, I think maybe not on mute, but okay, so you had two other questions, and frankly, I didn't properly.
Yeah, I just muted her. If she unmute herself, I'm gonna
Sorry about
remove
that, David. I got you by accident.
Yeah.
You could just unmute David.
Yeah, sorry.
about
So I
that,
was saying, Subra, I think your second question wasn't so much a question as a comment about having contacted a lawyer. So I'll leave that. But you
No.
mentioned.
Question there. What was
Okay.
the question there? The question was that what is this legal Crown Prosecution Act that bars anybody to prosecute or take legal action against government and the defaulting, in this case, say LTV, those who are for whom we are so suffering that we cannot claim damage or for their wrongful act or delay or all these things. So what is that special Crown Prosecution Act?
Okay, so I think what you're talking about is a potential criminal action against the government. Anybody in Canada can start a criminal prosecution against any other person, but the government, somewhat regrettably, I think, can intervene and then stay the prosecution. I'm not suggesting a criminal action against the government. We might have our own private thoughts about the criminality or otherwise of their failures, but this would be a civil action. So the RTA, the Residential Tenancies Act, is a piece of legislation. It governs the civil adjudication of matters. So we would not be looking at the Crown prosecution or the prosecution of the Crown in criminal court. So if the lawyer was talking about that, I think there may have been just a miscommunication about aims for litigants. But your question about seeking redress or help from the Ombudsman or the Attorney General and their concern about interfering with the independence of the LTB. The LTB is certainly independent. It's entitled to make decisions and act without regard to the influence of politicians. But they're dependent on legislation, and they're dependent on funding. And we're proposing that they be compelled to do certain things. They're independent to the point where they breach the law. And our position will be that they're in breach of the law, the very fundamental law of our nation, the foundational principles that underpin every single law in this nation. And to the extent that somebody acts contrary to that, or some institution acts contrary to that, they can be held to account. And our governmental system is set up such that every branch checks the other. The judiciary gets to watch what the politicians and the legislature are doing and to hold them to account for their failures. And so we're proposing to go to one branch of the government to compel the other branch of the government to do something.
Okay, do we have time for one more? Marissa's there with her hand up. She's had her hand up for a while. Maybe Marissa, do you have a quick question? Before we know that we're running out of time here, so.
Thank you. I'll ask the questions, and if we don't have time to answer it, that's okay. But I'm wondering what about this particular situation, small landlords and what's happening, what drew the Marshall team's attention to that? So why have you picked this to be what you advocate for? And the second question is one that came up in the chat. Can we start a GoFundMe to cover the potential losses if we lost and there was costs involved? Is that an opportunity there?
Good questions, Marissa, on both fronts. Why? Yeah, you know, that's an interesting question. it's a bit like asking,
My
why did I
sparkling
become a lawyer, or why do I like Coca-Cola and not Pepsi? I am generally offended by injustice, and I have enough clients who've been before the LTB to see it firsthand, and that kind of thing incenses people. You know, I have a lot of experience in administrative law, and yeah, if I could use a curse word, it peeves me off to see this happening to so many good people. I think the part that really irritates me, to be frank, is you have somebody who comes from another country, proud to be Canadian, proud to come here, sees a system that works, and wants to be part of that system. And they put their hard-earned money down and on the line. They put their family's futures on the line. And then when things don't go well and they turn to that system for help and it's not there, that really irritates me. So to be frank, it peeves me off. The GoFundMe question, interesting question, Marissa. There is a rule against what's called champerty and maintenance that may not apply in this situation, but I'd probably want to check that out before I gave a pronouncement on that. But off the top of my head, that doesn't sound like a bad idea. So we can certainly discuss that further, and we will make note of that as we go forward. So that may be a possibility. I hope.
Sir, have you
I hope
approached the REITs at all? I apologize for speaking out of turn. Have you approached the REITs at all in terms of getting them to possibly help you with the funding, knowing that the small landlord is the one who will be most compelling in a court case, but the REITs have deep pockets and they could certainly help fund this action. Sorry again for speaking out of turn.
No worries.
Who are you?
Go ahead, Buba.
Who are you, Mrs. L?
I believe that was Marissa again there.
Oh, no, it wasn't.
Uh,
Marissa.
So just
Oh, was
yeah,
That's okay.
L.
Okay. So we're going to explore all avenues. We don't particularly, I mean, the costs that, you know, we would be looking at for our purposes are photocopying and some other sundry costs that are in the low hundreds of dollars figure. Really, it's the risk that we're taking that it's unsuccessful and we don't get paid. I hope that addresses your, there's so many questions in the chat.
Yeah.
I guess I've got to go to another meeting, Boba, so I
We will
hope,
provide you the chat so you
Yeah.
guys can see if there are more questions that you can respond to. And
and I hope
we
that was
just want
helpful.
to, this has been great. We thank you so much, guys, for being here to explain things. We're going to give your contact information so people can reach out to you. I presume you want to get an idea of the story, so then you can set up a meeting in person to actually bring their story to you, and then you can kind of figure out if you want to actually go forward with some kind of a process or application. As Noreen says, you guys are doing God's work here. We thank you collectively as landlords, as small landlords, and yeah. So that's really the close of this meeting, and we
Yeah.
thank everybody for being here. And I don't know if you have any closing words, David.
Yeah, just thank you to everybody. And I know there were a lot of questions. I see some hands raised. I see Paranaz raising her hand there. I wish we'd been able to get to everybody who put the questions there. Hopefully what we can do is go through those questions. I think those will be informative for us in further understanding the issues that you folks are facing. And please feel free to reach out to one of our staff or paralegals or lawyers here, and we can have a further chat. I hope that was helpful, and thank you again for the opportunity to speak.
Thank you very much. Thank you.
Thank you, guys.
Thank you.
Thank you,
Thank you, everybody.
Have a good night, everybody.
Good night.
Okay, so it's over. What we can do, we're gonna put as a recording, and we'll give you access for people who wants to review it.